Today we're very fortunate to have Professor Joseph Gastwirth from George Washington University telling us about some civil cases in the U.S. Um, yeah. um,
Thank you very much, Ching-Wan. I'm delighted to be back at the Institute. I had a wonderful experience nearly 10 years ago when I was here when they had a special program on forensic statistics and law. Today I'm going to talk about how the usefulness of stat evidence depends on the relevant legal criteria in the U.S. civil cases. But the last case I'm going to talk about is a little bit different because it's current, and I think it'll be interesting. At least it's very interesting to me, and hopefully it'll be interesting to you all. The topics I want to discuss is first is matrix initiatives. This was a securities law case in which evidence of materiality to investors actually protected public health better than tort law, which we have our super expert here, Dr. Deacon, who's written the Bible there on tort law, co-authored, I should say. It actually you'll see it protects the public health better. Then I want to talk about survey evidence in infringement and misleading advertisement cases. This could be a whole semester class, actually, but I just want to talk to you a little bit about it. And there is a strong preference for having a control group when causality is needed, but not when, again, materiality is the criteria. And I want to talk to you about a case I think you'll find interesting, A. Cohn versus Trump University. I think you know you've heard a lot about the person who was headed that. And then I want to talk about interesting current controversy, which is about how the casual assumption of independence may lead to a much more stringent legal criterion for what they call a preliminary injunction. We'll get to what the legal meanings later. But it's just that let me just, for those, I know everybody here has been learning much more about causality than I'll ever know probably, but materiality may be new, and in the Second Circuit is New York, which has a lot of securities law cases, as you can imagine. False statement is material if it has a tendency to influence or is capable of influencing the decision-making body to which it's addressed. In other words, it could be a company board or it could be just an ordinary citizen. Similarly, information that should have been conveyed to the public or the decision maker, if it's an individual, was withheld, can also be material. Let me just give you a quick example. When I did some consulting years ago on discrimination cases, one of the issues that the lawyers, the company want to know sometimes is what is the worst, what is the more reasonable, if they lose, how much would it be? And they kind of had a rough rule of thumb. If it was less than a penny of an earnings share, it was not material. It wouldn't really, no investor would be too worried. But if it was more than that, they would have to announce that they had some suits. Now, causality, as you know, focuses more on whether there's a direct link. Now, the link doesn't have to be one stage. It can be, several stages in graphs, as you all know. But it's a direct link between the actions, or in some cases, the inactions, failure to act, of the defendant that resulted in the plaintiff, D is the defendant, P is the plaintiff being harmed. In a few cases, you have to prove both. In some types of fraud cases, which I know some special types, a plaintiff may need to know that the defendant lied about a material fact, but also that they relied on it, and that's their reliance that caused their loss of money or whatever it was, the damage. Matrix Initiatives was a small company, relatively speaking, in the pharmaceutical world, and in 1999, it began selling Zicam nasal spray. That's a zinc-related spray to alleviate symptoms of cold and flu. The zinc is supposed to help. but of course the product has other ingredients too, I assume. Shortly after the product was put on the market, the doctor notified the company after noticed a possible link between the Zicam nasal spray and the loss of smell. The medical term is anosmia. That's the medical term for losing your smell, your sense of smell, in a cluster of patients. In September 2002, a doctor in the Colorado clinic informed the company about a patient similarly, this similar situation. And by September 2003, a team of doctors in the University of Colorado had identified 10 cases of anosmia after the Zicam nasal spray use and informed the company. They ultimately, they did not mention the company in their first publication, but they did mention it at a conference, the name of the company and the product in 2004. Now, there were, after some of those cases, there were some lawsuits filed. And I know Professor Deacon talked to everybody a few weeks ago on causality and tort law. So, but some investors also sued because Zicam nasal spray was the major product of the firm. It wasn't like it's one out of 27 products. It was the major one. And they had sued when they heard about these things. And in April 2004, the district court, it was in California or in the West Coast, certified a class action. That means all the investors as a group who held Matrix shares between October 2003, remember September 2003 is when they heard about the case from the doctors in Colorado, and February is when it was made public, when they announced it at a meeting, a public meeting. And also some of the news reported in early 2004 too. So that's how that came about. And they sued them for not disclosing reports indicating that the spray was potentially linked. And as I mentioned, companies are required to inform investors about facts that would be material to whether they would hold the investment, sell it, buy it, whatever their actions would be. And by 2004, the Colorado group had evaluated about 100 cases. And then in early 2004, and that's why Dow Jones, which at the time owned the Wall Street Journal, so investors would be expected to read it, reported there might be a problem and that the FDA was investigating. Matrix, the company, responded that it believed reports of a link were misleading and they did not observe any cases in their clinical studies. The company did not mention the small sample sizes of the cases. You can see there are only 100, or actually 101, and obviously it's only the treated that can have a case, and the controls don't matter. In August 2005, a San Diego clinic reported that 15 of 17 patients who had lost their smell did so after using the spray for a cold. Now, finally, in June 2009, after receiving 130 adverse event reports from in the last 9 years, previous 9 years, the FDA advised the public not to use it and told the company its label was inadequate. But at this time, Matrix, the company, had received, these are numbers are approximately, obviously, 800 reports of loss of smell, but had not informed them to the FDA. Companies are supposed to report adverse events to the FDA. Now, for the purpose of the securities law case, I mentioned the period 2003, late 2003, early 2004, when the company knew and didn't tell anybody, and then is the key period. But in 2005, the district court, even though it had certified the class action, dismissed the case because the plaintiffs had not shown that the increased risk was statistically significant. Now, I should say neither the investors nor the firm had conducted a case control or any other study. But in 2009, The Ninth Circuit Court of Appeals, that's on the West Coast, is based in separate, and its biggest state is California, but it also includes Oregon and Washington, and I think possibly Arizona or Mexico. They reversed the district court and said, yes, the class action can continue because information that relates to a possible association between the firm's major product and anosmia would be material to investors, and by withholding reports of the adverse effects and the actual lawsuits, the firm misled investors. The company appealed the case to the Supreme Court, and in 2011, the Supreme Court upheld the Ninth Circuit, and they noted something. The medical researchers consider multiple factors in assessing causality, and that stat significance is not required, and that the court did not require proof of causality in cases where the information would be material to investors. Now, postscript. While several product liability tort cases, I mean, people who lost their smell, the plaintiffs lost all of them. Their expert did not conduct a case control or other epi study. I just want to mention two quick things. What I want to give you a simple proposal for a quick test of potential harm for new products. This is especially for that are based on adverse event reports. And this is based on a very simple stat one method. Consider what the usual, the one sample binomial test, where we essentially want to say there's a certain proportion, the event happens, you have a certain proportion pi, and we want to see if the data is consistent with that pi. The firm, now when you introduce a new product into a market like for cold medicines, you know that a new product is not going to have a huge market share. And even in 2009, before it had won the public, it gave its market share as 2.9%. So I'll use pi as 0.03. So just think at the start of you had the early report, and you had at least 10 users in the Colorado clinic. So in the Colorado clinic, everyone had used Zicam. So what's the probability that all 10 cases would have used Zicam? It's 0.03 to the 10th. That's infinitesimal, 5.9 times 10 to the minus 6. And even if the market share had been 10%, and for some reason, the p-value was 10 to the minus 10. Now, suppose the company had argued that there were many clinics, so something would happen in one clinic as by coincidence. We can use a multiple comparison theorem. Now, normally I would use Benjamini, Hochberg, and Fancy, but here we can use the old-fashioned Bonferroni. There are only about 12,500 ENT specialists, and they don't all have their own clinic, but even if they did, you can multiply that p-value, and it's not significant, right? 10 to the minus 10th, and it's still very significant. And if you do a Caulfield sensitivity analysis, which you all heard Paul Rosenbaum talk a few weeks ago, you show that the unobserved an unobserved confounding factor would have to have its own relative risk of around 10, of over 10 to explain. So it's just no way that, now this type of analysis is insufficient for a causal relationship because the adverse event reports are very ad hoc, and does a person complain or does a doctor's group? Okay, it's not systematic. But they should be material, but they should be enough to give a flag for this, something is going on, and you ought to be telling people. Now, a little more about the product liability cases, because it was very funny to me. The plaintiffs used an expert from the San Diego clinic that reported 15 out of 17 cases occurred in Zicam nasal spray users. And they wrote 2 articles, but they did what they call a case-only analysis and claimed that the criterion for causality in the famous 1965 paper, Bradford Hill, would be satisfied. Now, common sense tells me, why don't you use, especially when you have a big clinic, why don't you make your own case control study? Now, in this case, you would want to do it something like age matched, and maybe other criterion, health related. You don't want to have, you don't want to compare people who, one person's in very good health with someone not. But you could have had a matched control study. Now, for the purpose of this, since I can't create a matched study without a whole lot of assumptions, and there's a classic short paper in the Annals of in the American Journal of Epi by the late Sam Greenhouse and Dan Siegel that generally shows that ignoring the matching will give you an underestimate of the relative risk. We'll just look at the type of data we might have gotten. Of course, the cases we would have gotten 15 from the exposed group and 2 in the unexposed. And the controls, if we had 2 controls a case, you could have X and you could have 30, and you have 34 minus X, right? Because you had 51. Now, do a little bit of math, which I won't bother you with. I use Fisher's exact test. You could argue that I should use an unconditional test like Berger and Booz, but we don't have to worry about that for this purposes. Our discussion, in order for you not to have, as long as the number X as long as that number X was less than 20, you would be stat significant. So in order not to have not to be stat significant, you would have had to have X to be 20. And you have to have a big number to be not, right? Because 15 over 17 is very high, so you have to have a fairly big number not to be statistically different. So you'd have to have at least 20, or at least 68% of the controls would have had to develop anosmia. It's unbelievable, right? That 68% of the controls, right? Because everybody we know would have, nobody, would, okay? So now if you look at the results from the NHANES, that's the national health, one of the 2 big major national health surveys, the prevalence of anosmia in the general population runs around 3 to 4%, but it rises to about 20% at the higher age groups. But of course, we're really looking at incidence because these people get anosmia within, say, a week. So this would be much less. So it's just not plausible to believe that a small case control study would have failed to detect a substantial relative risk of the symptoms from the exposure. So you really wonder what went wrong in the. Now, to go to the next 2 topics, I need to give you a little bit of background in the U.S. civil law. Now, I'm not a lawyer, though I did listen to a few classes in the law school. After a case is filed and the judge decides that the case is legitimate, plaintiff has standing, they suffer some kind of harm in this type of case we're talking about, and that the statement of the case was clear to the defendant, so the defendant knows what that, you can't just say, I used your product and I felt bad. You have to give the defendant knowledge so they could, study the situation and come up with their own explanation, which, and this is a general rule now. Now, once these preliminaries are taken care of, and the judge says, okay, we'll go on with the case, there's a period of discovery where the parties request information from each other. In a case like the Matrix, they would have been asked about if it was an individual suing a product liability case, they would have asked for the adverse event reports and maybe some other questions about the chemicals in the product. And similarly, the company would have asked the individuals for their medical history to make sure that they don't have a genetic, trait in the family or something that would do that. But they do that, and then there's something called summary judgment. And this is when one party says, one side, it's usually the defendant, usually the defense does this. They request what is called summary judgment. It means that the case should end. There's no major facts available that would indicate the other side should win, so we should win. Now, at that stage, of course, the trial judge is supposed to favor the party that would lose. In other words, if there's some evidence, the standard is something like, if it is plausible that a juror, if the case would go to a juror, often cases go to juries in the States, if it's plausible that a juror could interpret it in favor of the party that would lose, summary judgment should not be given. Okay, many times summary judgments are reversed on appeal. Now, similarly, a party might request a preliminary injunction, and I will go more into that a bit later, that prevents the other party from continuing. In the case of Matrix, it would be they stop selling the product, but until you had the trial, then if say it was the FDA, we had a more active FDA than we do at the current moment, as you probably know. Then if the FDA lost, then the company could put the product back. And then there's one other case that statisticians should be aware of if they ever get involved with legal work, especially in the States, interpreting legal cases. It's a case called Daubert. And this was a case that was written by the late Judge Harry Blackmun. His most famous decision, many of you even here may have heard of, it was the Roe v. Wade abortion decision. And Blackmun, although he's a lawyer, was actually in his practice, he was the Mayo Clinic's lawyer. So he did pick up a certain amount of scientific knowledge. And in that case, he gives people, the Supreme Court gives the trial judges the responsibility to screen proposed expert evidence to make sure you don't get, the jury doesn't get quack evidence or phony evidence. And Blackmun gave certain criteria, such as the methodology should be peer reviewed, some things shouldn't be known about the error rates, things like that. So it's kinds of things that you and I would look at, when we looked at a method. And now I should say, in the States, at this stage, over 90% of the cases now get settled. Once the court says to both sides, I'm letting your experts testify, then they get down to business and start trying to settle the case. Whoops. Okay, now we come to commercial law, and there's a whole, this is again a whole field. But in commercial law, there are things called trademark infringement. And in trademark infringement, some company, typically a newer company or another competitor, may try to confuse the consumer to think that their product is the same as the original. It's often done by similar design and packaging, okay? And then there's a related topic of where they could do some misleading advertisement, okay? And if they have a misleading advertisement, they'll say their product will make you feel, you'll feel better faster, or you'll feel better for longer, or something like that. That's from the competitor. Now, when obviously there's a whole set of related topics here, but when causality is an issue, the survey should include a control group or other ways that with a control question, and all surveys should have a don't know or can't recall option, because you want to eliminate the misconceptions the public might have had, because these products marketed to the general public, they might have had from pre-existing knowledge, mostly from pre-existing ads and stuff. Now, before accepting a survey, courts often review the questions to ensure they don't suggest a response or force the person to respond. And I'll give you an example from a case which the court did not accept a question. And they were showing, it was a deceptive ad case, and they showed two ads. And the first question was, does it appear to you that one company borrowed the slogan, there was a slogan in question, in question, from the other? If yes, which one? Now, the judges were unhappy because a don't know option wasn't given. If somebody could see the ad, in the two ads, and say, geez, I don't know. So in some cases, you can have 75% don't know, in which case there's not much confusion in the public. So that survey wasn't accepted. What's going on here? Okay, now it comes to the Acone versus Trump University. In 2005, before entering politics, President Trump started a, quote, university, unquote, to provide training to individuals interested in pursuing careers in business and real estate. The marketing emphasized that he would be very involved in the university. It would have regular faculty and it would have adjunct faculty, just like my university at home, and Cambridge probably does too. Okay. Trump University held real estate investing seminars, including special 3-day ones, and they had a Trump Elite, that's a more involved program. And after a few years, a number of people who took the classes said that, we didn't learn very much. And as far as we know, our instructor wasn't picked by Trump, didn't know Trump, and we never saw him, and so they went to court, and in 2014, a court certified a class action on behalf of those individuals who had purchased a Trump University program and they look at the price range that was $1,400 to $35,000. Now, I don't know how many people paid $35,000, but obviously quite a few people paid the $1,495 and probably a little bit more. So the plaintiffs claimed, this is the statute, that the defense, Trump University, committed fraud and racketeering by marketing the university as an actual university in which Trump would be integrally involved. I mean, that was it. Now, our discussion is going to focus on the court ruling on the admissibility of the plaintiff's survey evidence, which was a Daubert motion, it was a Daubert decision, and the survey's role in the case. Prior to that, other evidence which had been introduced during discovery, they had deposed Trump, and it was clear that President Trump at the time, Mr. Trump, had not participated in selecting the instructors. The ad said he would handpick them, and he had little involvement with the curricula. He didn't say we should do this and that, cover, whatever, types of calculations you do for amortization of mortgages, and nothing like that was, he did not solicit. So the purpose of the survey was to demonstrate the materiality of the university's misrepresentations concerning Trump's involvement with it and its programs on the decisions of prospective consumers. Okay, so that was what the purpose of the survey was. So first, you have to take respondents who are sufficient age, that they would, you wouldn't survey school kids, who might be adults who are not yet involved in real estate or Trump University, and they sample a number of people. Usually they do this at shopping malls or other places, but often places that you think you would find people possibly interested. Like if you were doing, a colleague of mine once did a survey involved in running shoes, and you went to a running meet, something, a high price running, and they were shown two promotional ads and part of a video, not the whole video, because the whole video is 90 minutes, that are used at the start of a 90-minute free preview shown to prospective students. Then they were asked to indicate on a scale of 1 to 9 how likely they were, how likely they would be interested, to enroll in a program if it were convenient and reasonably priced, things like that. Would you be interested in this program? And 1 was very unlikely, 9 very, very likely, extremely likely. And then they look at the people in what we would call the upper portion, the ones who expressed that they might be interested, right, some interest. They asked them some further questions. They didn't ask the ones who showed no interest. And then they were asked, because remember they saw the promotional ads which mentioned Trump. So they said, would the opportunity to learn Donald Trump's real estate strategies and techniques have a positive impact, a negative impact, or no impact on your decision to enroll? How was his involvement? And second, would the opportunity to learn from instructors handpicked by Donald Trump have, again, on your decision to enroll? And 87% said yes to the first, 83% said yes to the second. So you can see that this is a whopping survey, okay? If this was a patent infringement case, if this was a trademark infringement case, this was off the wall, okay? This is very high, which is what you'd expect, of course. You expect that people who are interested would be, if you're interested in going into real estate, right? You, especially at that time, you would be interested in. Now, it's very interesting. The defendant criticized the survey because it didn't sample potential customers. And I'll explain that in a minute. And the number of people answering 1 through 5 on the screening question were not reported, and it did not have a control group that's usually needed to establish causality. Okay. Plaintiff explained, rebutted, and answered these criticisms because the university, when they said potential customers, while the university did make some effort to contact people who had expressed interest in real estate, they made a lot of they advertised a lot to the general public. So therefore, it was perfectly reasonable to sample the general public. And the judge himself noted that it would make little sense to show the video and other things to individuals who were not interested. And I would just want to point out to you, look at the inconsistency of the defendant claiming the survey did not sample potential customers, but wanted to know more about the people who didn't express an interest. It's illogical. That often happens, I'm sure. Professor Deacon can tell you he's seen that too, I'm sure. And now C, and this is important for us, the purpose of the survey was to show that the misrepresentations were material to individuals making a decision to enroll, not to demonstrate causality. So this is material. Over 80% indicated that Trump's involvement would have a positive impact on their decision. Now to prove causality, usually in a garden variety misleading advertisement case, you do have a control group and you take away the so-called misleading segment from the ad and you show that ad to the control group and then the full ad, and you get a differential response on what they say, which product is better or whatever it is. But in a case like this, I don't see how you could possibly edit Donald Trump out of the video. if you know anything about his personality, there's no way you're going to be able to edit that. So trying to do a causal control group like the standard one is impossible. Anyway, the court found that only one of the six criticisms had any merit at all, and that was the control group. But he said that for results of surveys without control groups have been accepted as evidence of materiality all the time, quite often, as long as they're well done and they had a don't know. Remember when they said the positive impact, negative impact, don't know, as long as they are well designed. Now the ending was that the trial was scheduled to begin in November 16, 2016. This was just after Trump was elected the first time. And this case and in a related case was settled by DT for a check of $25 million. Now, so he had to pay out $25 million. And actually the lawyers did not take their fee. They said they'd rather have the money given to the people. Very interesting. And note again, of course, after the Daubert motion, after the expert is admitted, then the settlement happen. This happens a lot. I don't know if this happens a lot in the UK, Professor Deacon, but and Martina, you may know, but it happens here too. Okay. Now I want to jump to a little different topic, and the reason is it still may be going on. This is a case called the American Federation of Teachers versus Besson. Besson is our current Secretary of Treasury. This is the casual assumption of independence. This is not the causal. The current case arose when President Trump, in his second term, created what he called the DOGE, the Department of Government Efficiency, under Elon Musk. And they were supposed to make the government more efficient. I will not comment on what I think they've done. And what they wanted to do is get access to the complete personnel files. Now, the word complete is very important because you could have asked what jobs these people have and what do they do on their job. That would be related to government efficiency. How much money they may have contributed to the retirement, it's a little bit different. So certain people in the unions sued, and they went to a district court in Maryland, and they did obtain what they call a preliminary injunction. Now, a preliminary injunction simply says to DOGE, you can't get the records now. We have to have a trial to show you have the legal right to them. And then if you do have the legal right, then you get the records. If you lose, if the plaintiffs win, then of course they don't have the right. They succeeded at the district court, but in last August in 2025, in a split 2-to-1 opinion, the appeals court, that's the Fourth Circuit, that over Maryland, Virginia, and the Carolinas, overturned the original decision. Now, the reason it's important is because statistics, stats has a role, as you'll see, and it's important legally because it increased the standard plaintiffs have to meet to obtain a preliminary injunction. Obviously, to get a preliminary injunction to stop the other side, you have to have more evidence than just that you would probably win a trial. You have to have a few other factors, which we'll come to. Now, in a different Supreme Court, an earlier Supreme Court case, they give the factors for a preliminary injunction. And they're more stringent and they're more likely than not standard that you're used to at an ordinary civil trial. First, you have to show you have a good, high likelihood of success on the merits, that you're likely to win, okay? So that two, there's a likelihood of irreparable harm to you, like in the Matrix type of case, where this would have been a little different. Your harm would be that you wouldn't smell for several months or a year. Who knows? And that then this is a more legal term, the equities favor relief. That's the balance of relative hardship favors the plaintiff. And 4, this is very important, the injunction is in the public interest. Now, I think it's pretty okay, right? Pretty clear in a case like Matrix, that a preliminary injunction, if the FDA was active, would have been in the public interest because it would have prevented more cases, right, in almost any public health issue. Now, after noting these criterion, and they discuss, the plaintiffs faced with, they write, the plaintiffs face what can be called a multiplicative problem. Their likelihood of success is the product of the probability of success on each of the independent dispositive issues. So all of a sudden, the evidence for each of these issues is independent, and so we use the multiplication rule, and it notes that as you multiply more and more probabilities, the overall number shrinks. And it concludes with, plaintiffs therefore need to show an extremely high likelihood of success on each individual issue in order to have a normal likelihood of success is greater than 0.5 overall. Otherwise, the product of the probabilities will be too low. Now, in the issues involving the success on the merits and the equities, really involving 2 acts. There's the Privacy Act, which applied to the federal government, and there's another act called the Administrative Procedures Act. Now, I have never, I've been involved with the Privacy Act, but I know nothing about the Administrative Procedure Act. So I'm not going to discuss that. The legal stuff, in our paper, we refer to a legal note. But what's important to us is that rather than reviewing the main legal issues, like do they have standing, which we talked about at the beginning, that they, which would be pretty obvious in that case, but the other part is the intricacy. These acts are very complicated. There are loads of loopholes and so how you figure this out, and that's. But rather than going into those legal aspects, this is what the majority say. It relies on a statistically surer conclusion. The plaintiffs have failed by a decent margin to show that they will likely prevail on all of these issues combined. And they say the district court abused its discretion in finding that plaintiffs were likely to prevail on each one, and with such certainty that they were likely to succeed overall. Okay, so that's why it's interesting to me. I hope it's interesting to you. Now, the dissenting judge criticized the majority for conjuring up a higher bar for plaintiffs that they need to show an extremely high likelihood of success on the individual issues in order to have a normal probability of success overall. And he argued that the district court properly evaluated the evidence pertaining to each criteria and concluded that the plaintiffs satisfied all of them. And he said that the district court made the correct analysis given the information that was submitted. In all these cases, at least in the States, the court is not supposed to do its own analysis. The court is not, you are supposed to, if you're on a jury, which I've been on, you're told you're not supposed to look at the crime scene. You're supposed to just let's see what is put in the court. Now, understandably, the judge's dissent did not emphasize the important role that the assumption of independence had on the calculation, because in a paper which we just submitted with Professor Wenwen Miao and Xing Pan, both of whom I've written a lot with over the years, we cited a legal article for a discussion of the relevant statutes and how they interplay in the case. But we emphasized that there's a law, statistics, and law literature concerning the fallacy of assuming independence without checking that it was. And it's in the legal literature, not just in the stat literature. It's not new. In '68, there's a very famous case called State v. Collins. It's a California case where an expert assumed that a woman had blonde hair and having a ponytail were independent, as well as a man having a beard and a mustache who was black. And there was a big issue, a big section of a Harvard Law Review piece on this. A very famous law professor, Lawrence Tribe, you probably, I can see Simon is mentioning his name, and a very famous statistician, Fred Mosteller, wrote on this. So this is so, and in my own 88 book on statistical reasoning and law and public policy, I discussed the Collins case, and I also mentioned a similar 66 case from New Mexico. It's called Sneed from New Mexico, same type of error. And then I mentioned a case of the late Judge Jack Weinstein, who he's most famous for the Agent Orange case, where he discussed in U.S. v. Fatico was a case involving whether some people were involved with some criminal gang, like a crime family. And he emphasized that wait 1 second. He emphasized that the police detectives who testified had relied on independent informants. He actually stresses that in his decision. Okay, Weinstein was one of the more scientifically, quantitatively swift judges we had. You had a question?
Well, a comment. This is super interesting, and I think what I was going to say is this specific case you mentioned with the 4 criteria. There is something else I think going on there, over and above just the fallacy of assuming things are independent. I think there is some equivocating happening, where if you think about those 4 issues legally, you think of them like as legally independent issues you have to establish, which is different from probabilistically or statistically independent, right?
Yeah.
Like things could be conceptually distinct, but not probabilistically distinct. And I think there was some equivocating between 2 meanings of independence happening in that ruling.
That's a good point. I guess I would have used for the legal thing separately. You consider each one separately, but the body of evidence. Well, you'll see in a second. I'll come to the next slide. But it's a good point that it could be a misuse of words. But then you still would have thought, especially that circuit has a lot of cases. They had a lot of discrimination cases. They should know about statistical independence, because discrimination, the binomial model which I gave you when I did the adverse event reports is the same binomial model they use for jury discrimination cases. If I want to see, am I representing women or minorities fairly, I look at the proportion of minorities in the jury eligible population. And then I say, let's say it's 20%. And then I look at my composition of the people called to jury service, not necessarily who actually got on the juries because of the different ways people get excused. And then you compare that with that test, that binomial test. So I would have thought that the judges there would have known, or they should have known. Let's put it that way. But just as a little bit of extra background for you, because you're obviously very knowledgeable legally, is that the judge who wrote the opinion was a Trump appointee from his first administration. The one who agreed with him was a Bush II, not a Bush I appointee. The dissenting judge is a Clinton appointee. He still stayed on the bench. So I'm sure that doesn't surprise you given your knowledge, but I just a little bit of background might be helpful. Now, also, and this is interesting, the case that arose in Moultrie v. Morton, this is a Fourth Circuit case, same circuit in '82. And Wayne Meow and I wrote an article in the Geometrics around 2002. It concerned the possible bias in the selection of grand juries. Now, in the States, in a criminal case, before they can take you to trial, they have to get an indictment from a grand jury. And usually these are considered routine, but we'll come back to that. The main thing is that grand juries usually have 18 people. And normally, in most big cities, you would have 18 new people sampled every year. In this in this particular county in South Carolina, they took 12 new people each year, and half of them, 6, were kept the second year. So that meant that the juries each year had a common component. They were not statistically independent. Now, it's not a huge amount of dependence, right? It's what we call M dependent when M equals 2, but there is some dependence. Now, what's interesting is the court noted this, the actual decision in this Fourth Circuit in '82. The judges knew it, but they said, but they don't know how to handle it. They just know you can't expect them. So we wrote the paper, and just it's a rough thing. If you think of the normal form, that little dependence is equivalent to like a half a standard error, which is quite a bit. It's not a trivial even because it's a 1/3 overlap in 7 years. They had about 8-10 years of data. So I'm saying that that same issue is known in that Fourth Circuit. Anyway, and then in the 2005 securities law case, and I was the expert for the defense in this case. I had a former student who had taken stat with me, but he went to Harvard Law School, was in a major firm in New York. And this, a little bit of background, this concerned the dot-com boom when there were a lot of new initial public offerings. Now, you may have heard that Elon Musk is putting together his companies and wants to make a public offering. That's called an initial public offering. And back in the dot-com boom in around 1999, there were a lot of initial public offerings. The big advantage is that if you can get in the initial trade, usually these stocks went up. The biggest one that many of you have heard of in statistics is the Linux. You heard the Linux operating system? That company, that shot up dramatically. Okay. So there's a lot of game playing, and there was some way of doing indirect kickbacks. You can't pay somebody to give you. It was indirect commission business. So the regulators looked at the amount of commission this brokerage house had on the days they gave out IPOs, and then on non-IPO days, and they found a stat significant difference with the Wilcoxon test at p-value 0.04. But if you know anything about the stock market are not independent. The days, the prices today are not independent. They're not. There's a lot of correlation. And Yulia Gell and Wei Wenmiao and I, and Yulia actually was the expert in time series, and she fitted the models. For the IPO days, actually a first order regression was okay. For the non-IPO days, it was a complicated ARIMA model. It had to be very complicated because the non-IPO days include days like the day before holidays, which of course very quiet. It really was a stacked comparison. So anyway, then we simulated data with a normal distribution, exponential distribution, and we always got p-values of at least 0.16. That's quite a difference, right, between 0.04 and 0.16, right? And then for the more mathematically inclined, there's a paper by Shanti Gupta in the old annals of math stat in '63, where he computed. In those days, it was really hard to compute. You didn't have any R. There were no packages. The joint probability of if you equally correlated normal of getting all positive, and if they're independent, right, their chance of getting positive is 1/2 to the 4th, which is 0.0625. But if they're equally correlated with a correlation of 0.5, it's 0.20. Again, quite a big difference. So so just a reminder, in Gerald Van Bell in his book, Statistical Rules of Thumb, he talks about the relative importance of several common assumptions and what you have to worry about if it's violated. And he said independence is the first, equal variance when you consider two populations, equal variance is next. And the last one is normality. And of course, as you know, in many applications, normality goes away because we have a CLT, a central limit effect, law of averages, So Now, just to conclude, because we're running out of time, I want to consider the 4 factors in a preliminary injunction in a fraud case. Just think of a fraud case, because we discussed the Trump case. Just think about it. Presumably evidence that it would have that would show you as a high likelihood of success on the merits, that this ad and this stuff is fraudulent. It would certainly support the conclusion that an injunction is in the public interest. You certainly don't want the public to be defrauded. Right? I think of a scam, right? You know, obviously, if I could show that, if you had evidence that that body of evidence, that goes to the question that the gentleman at the back raised, the body of evidence for both of those aspects, and it would also prevent irreparable harm, because if you know anything about fraudsters, they often spend the money very lavishly, and so there's not much left to recover if you do. Where are you going to get the money? You can't get the money back after the person has spent it. So it's very, very difficult. So therefore, you can see in some cases the bodies of evidence that are needed to satisfy each of the criterion are likely to be positively dependent, which would imply that using the joint probability with the multiplicative rule underestimates their true probability, as we just saw. Now, of course, there could be different types of cases, again, where the evidences could be negatively related too. I mean, I don't know, depending on the criterion, you know, and then you would have a different situation. But then they probably wouldn't ever get a preliminary injunction in the first place. Okay, now, the plaintiffs have further requested the Fourth Circuit to hear what they call en banc, all 15 judges of the Fourth Circuit. They have not decided yet whether to hear it or not. In part, there was a slight delay in the process because of the government shutdown. We had a government shutdown in September, so certain people who weren't working. So whether the Fourth Circuit will review the case and require lower courts not to make or accept unverified assumptions and check that they're do what we want, what we as statisticians want them to do, check at least that the assumptions are approximately violated. That's going to be determined fairly soon, but don't hold your breath, because the legal process is not fast. And especially, it may be difficult to get all 15 judges together at one time. Getting an en banc panel may not be so easy, because, you know, some are based in Maryland, I mean, their homes, and some are in different states. But I hope I'll be able to write to Ching-Wan and Martina and Professor Deacon, and he'll tell you all that something happened, but we don't know. So first they have to agree to take the case, then there'll be more filings, and then they will hopefully decide the right way. But the way I think, it's pretty obvious the way I think they should decide. But no, I mean, they may send it back to reconsider the whole thing in light of other factors, because there may be other factors on the legal side that we don't know about. But I hope they don't. I hope they reject this multiplicative idea, you know, without any checking at all, just assuming it out of the blue. But you might have explained why they could have fallen into the trap. But I assume that the dissenting judge would have explained something to them, but they just didn't want to listen. Well, thank you very much, and I look forward to your comments. And don't be bashful about criticizing what I said about the last thing, because that's still current.
Neil, thank you so much. So I just think this approach of identifying various factors before making an overall assessment is very, very common in many areas of law. You might have 5 or 6 factors and the court weighs them up, but identifying these is a very artificial process. These things don't exist in nature. There's normally some kind of legal assessment of a particular question which involves breaking it down into various components. So saying there are 4 things you have to show in order to get an injunction. You know, it could be one or two, or it could be 5 or 6, right? So then they say, if you have to show the probability of each one, and as you say, if you then just multiply them, then you end up with this very low probability. It's just exceptionally artificial all the way through, isn't it? Because inevitably these things are going to be connected. If you say the test is whether you're likely to win a trial, and also whether there's likely to be irreparable damage, those two things are probably connected in some way. Yeah. And if a court did this on a frequent basis, I've never seen this done before, it would be a sure way to prevent otherwise meritorious claims proceeding. Because this particular judicial technique is extremely common. So it just strikes me as an extremely artificial approach to deciding any case. We have similar principles in English law about the balance of convenience when granting an injunction in all sorts of contexts. But as far as I can remember, I've never seen an English court take a statistical approach to this. They just invite the judge to make a looser assessment.
That's very interesting, son. I'll have to talk to you more, get some more references. But I had not seen this before. This is why it's interesting to me. I had never seen this before either. And it seems to me that there's that it was just it's like a little knowledge is a dangerous thing. Somebody learned that if you have pair of coins and I flip them 3 times, like they had studied about having how many children of which sex they're going to have, and all of a sudden they apply it here. I just don't. I'm glad you said it, but I had never seen anything like this before.
I think that's right. So sometimes you see a court ignoring a perfectly good statistical argument. That does happen. Sometimes they just ignore it. But here, it's as if they, as you say, they've got a. I wouldn't say they've got any understanding at all really of what's going on. It just sounds convincing. So it's clearly one of those decisions which is highly politicised because of its context. So what the court's striving to do is come up with some justification other than the rather obvious one, which is in this particular case, it's a very political decision. It's about an extremely controversial matter, about what Doge is doing. So introducing this sort of quasi-scientific evidence into the legal judgment has almost nothing to do with statistics as a field or a discipline as such.
Except that it's going to affect express. It's going to if this case is not overruled in some way, the Fourth Circuit is going to create a lot of confusion in that circuit, and it may be other circuits, because you remember we have a certain president appointing the new judges, and so they may just latch on to this and say, well, we'll just follow this decision. Notice this is also the easy path, because they didn't review. I was on the ASA committee after the Privacy Act was passed in 1974. So I do know something about the privacy. I do know, one of my friends in the law school, Bob Park, was administrative law expert, but I never listened to this class. I don't know anything. Administrative law is very complicated. Administrative procedures are very complicated. You have to give notice, and it's all. So how those two laws will interact, and with the exceptions that they have for certain things, and also the issue. Doge was created by the president. Though he calls it a Department of Government Efficiency, I don't know whether it still has the same statutory status legally. I mean, I don't know. As a department that's created by Congress, but that may also. So these are very. So what Professor Deacon is saying it may very well be true. Instead of getting involved with the law, which they're supposed to be the experts on, let's get rid of this problem by doing this other thing. But that's remember, in the U.S., I think it's true here too, but in the U.S., the federal judges have life appointments. So it's perfectly fine. You have your job, you're not going to get fired, and you're reasonably well paid. You can afford to say, we're going to do the right job. And you can, how do I say it? I can think of it for myself. I mean, after you get tenured as a professor, you have a certain amount of things. But once you're a tenured professor and you have a certain amount of money in your retirement account, then you're really independent. do I make sense to you? You could say, I want to work on this problem, I want to work on that problem. I don't really care because I'm okay. Now, obviously, what is the right number will depend on different people. Some people want to have a new Cadillac every 3 years, and they have a much bigger number than I have. but it's very interesting. But I'm glad that your English law never had something like this, and I hope our law doesn't have any more cases like this. Because, but what this will do is this is going to, if this were to spread, it'd be very bad for public. You saw how long it took. Of course, loss of smell is not that serious, but there are other diseases where the government was able to act fast. I'll give you some examples. Years ago, Procter & Gamble is a more responsible company. Introduced a high absorbent tampon for women. And it turned out that they had a disease called toxic shock syndrome. And a lot of the public health agencies in different states got together and they started doing case control studies. And it was actually pretty easy to get controls because one of the things they used friend controls. And they were able to show that it had a very high relative risk. And then they went to P&G and they got them to remove the product from the market. But there was another company, which I won't name, that did not remove its competitive products. And later it got sued and it got hit for $10 million. This is back, it's be like 25 today, because the jury said that you get punitive damages if you're really bad. And they said, the jury said, look, the other companies take off, you can't do this. And then the trial judge actually, the company said, well, we'll take it off the market, so reduce the punitive damage. But the 10th Circuit, which is a conservative circuit, reversed it and said, no, the punitive damages have to hold because the company was really bad. But there have been cases, and Rye syndrome is another case, where a situation, which is aspirin in young kids, where after a few years, now the industry fought that, delayed it a little longer, but not nearly as long as this. The government just said, we're going to have another study, delayed it 2 years. But then the UK was funny too. The UK would not accept the US studies on Rye syndrome. That's in the paper I showed you. Yeah. And so the UK, the drug company, the manufacturer in the UK told them that UK has a different weather pattern. Now I better tell you, the relative risk of using the Rye syndrome, okay, that's used to kids versus was around 30. Even with Paul Rosenbaum talked to you about control groups. There were 4 different control groups. 2 of them were suggested by the industry when the first, those had the highest relative risks. Okay? So, but the UK said, oh, yes, because the UK waited a year. They said they'll have their own study. So you probably had maybe 20, 25 kids die because they wouldn't accept the American study. So this is not this is, we talk statistics as, there's a lot of, and we talk law as idea, but there's people dying because of people not really thinking things carefully and realizing that there's huge decisions made here. And this is the case where some of the work that you're learning on the causal inference program is very, very important, because when you ask yourself, like in the UK, when the people say that the weather is different, you have to ask, is the weather so much different that it's going to explain a relative risk of 30? Yes, if it's a relative risk of 1.3, possibly. 30? No way. Okay? No way. Well, at least I don't think it's any way. Maybe. Yeah, just do any. Yeah, so how we can get this is actually this should be another program for the institute. How do we get communication of these ideas to the policymakers? How you get that's very important. You can come up with wonderful results, but unless
How do you get it to the judges? I think the American judges are at least familiar, or more familiar, I think, with the use of statistics, and there are journals like Jurymetrics, which people, law professors publish in. We don't quite have the same, I think, culture. The courts don't get enough training. Judges don't get enough training, I think. Yeah.
Can you do one more question?
Sorry, I'm really sorry.
we'll be in touch.
We'll be in touch.
Great to meet you.
Yeah, thank you so much. I'm hoping these slides are available, but I just wanted to.
They are.
Great.
I gave everything.
I have short
Also, I just had like it's interesting to me how conclusions based on statistical evidence kind of make their way into law. So, for example, probably you can do a successful tort these days based on the fact that cigarette smoke is bad for you, for your health. But of course, there is no randomized trial for this. It's all based on this kind of indirect evidence you're talking about, on relative risk being super large, and there being not sufficient confounding factors to explain all of that. I mean, that's how epidemiologists concluded this, right? Eventually there was a mechanism and so on. And so I think it's interesting, like, how eventually this becomes accepted in the legal profession that certain things are bad or harmful based on this kind of indirect observational evidence.
I'm not so sure that the smoking, because I had the good fortune of learning a little bit about that topic from Jerry Cornfield, and Cornfield had this inequality was the appendix of a 59 paper of the JNCI. I think that you remember you cannot have a randomized trial. Once there's a suspicion that something is harmful, it is not ethical to randomize people to that particular treatment. In other words, supposing we had let's think. There was some new medicine that came out, maybe some just a new popular drink that came out, and but unbeknownst maybe to the maker, somehow when it's made and some of the ingredients, there's a cancer-causing compound in it. It starts being marketed. Well, I mean, maybe cancer probably takes too long, or some more harmful thing that shows up fairly fast, like this loss of smell, maybe loss of taste. All of a sudden, this is marketed. Now, once you see this, and you see some cases, can you now randomly assign 500 people to take it and 500 people not to take it? I don't think you can. I don't. Do I make any sense to you? It's not ethical. It's not right. You wouldn't want that, right? But you don't want to be in the experimental group, right? So basically, if you're not willing to be in the experimental group yourself, you shouldn't make anybody else there. Put anybody else there. So that's another one. So many issues you cannot have a randomized trial. Secondly, you couldn't randomize people to smoke or not to smoke, because some people don't want to smoke, period, for other reasons. So sometimes you have to, and you're right that it's logically, it's always possible that there's some other mechanism. But we now know that it's not. And sometimes for public health, you've got to, how much evidence do you need? And that's the interesting question that you raised. How much evidence do you need? Because in some sense, a real Bayesian, you posterior, you can start, and as I did in this little paper I wrote, you start with some prior knowledge, you get a new one study, you get another study, you update it. Certain times your posterior probability gets to be very high. And for smoking and lung cancer, they must have had 20 or 30 different case control studies.
I think you look for a natural experiment, if possible.
Yes, but can you get with a natural experiment in, that's a good point, Nick. Is that a good, but how would we get a natural experiment in smoking?
Well, where maybe some institutions ban smoking. I don't know. It would need a lot of thought. But
Okay, I can see that.
it is conceivable, I think.
It's conceivable, but then you have to be careful. The type of institution that might ban smoking at that time that he was talking about might be something like a nunnery, which would be a much different population in many other ways than the general population. So you'd have a problem. You're right. Sometimes there are natural ways you can do that. It's possible you get it maybe in religious groups too. But you'd have to do you'd have to check on a lot of things. You could do it if you had matching. If you had a lot of data, you could match people on many different health-related factors. Yes.
I couldn't design you a study here and now, but it's conceivable.
Well, we'll put you on the agenda for next year.
Just to say, I'm aware of time, and so Professor Gastwirth will be with us over lunch and
Yes.
in the afternoon.
Yes, I wanted
And
to.
we can continue our discussion. Let's thank